If you could combine the power of law and courts and what they provide if you have the financial means with the power of community activism and campaigning, you really had this potential for creating big change where other mechanisms have failed. So litigation is really, really powerful where you've got intractable issues where governments or corporates can't or won't act. And so you kind of, I guess, start to worry less about whether they're doing what they're doing because they don't want to or because they can't, and you focus on actually just making sure that they obey the law. With that kind of principle in mind, I'm sort of wondering, why aren't we having more of this sort of big litigation in Australia the way you see globally? And the answer to that question is complicated, but part of it is our adverse cost system. That means that if you bring litigation, you have to pay the other side's legal bill if you lose. And that's a pretty fair principle for the most part. But when you're talking about a remote community trying to enforce their legal rights, it's completely unacceptable.